Good morning, India, and a very warm welcome to everyone joining us live on LinkedIn as well as YouTube. Today is January 13th, and it's 9:30 a.m. in India. Thank you for starting your day with a conversation that is central to India's digital future. India's Digital Personal Data Protection Act makes a fundamental shift in how organizations must think about personal data. This is not just a legal change, it's an operational information or transformation. The DPDP Act places clear responsibility on organizations to obtain valid, purpose specific consent, respect and response to data principal rights, and most importantly, prove compliance continuously. Two areas where organizations feel the most pressure today are universal consent management and data principal access rights. And that is exactly what we will unpack today. Why this conversation matters now? Let me be candid. Many enterprises already have privacy notices, consent language, legal interpretation, manual DSR or DPAR processes. Yet, many still feel unprepared. Why? Because manual compliance does not scale. Under DPDP, consent must be traceable, revocable, and purpose bound. Data principal requests must be fulfilled within defined timelines. Evidence must exist before a regulator asks for it. Compliance is no longer episodic, it is continuous. It's a privilege to be joined by our eminent private leaders today. Vijayashankar Nagarajarao, Chairman FDPPI, one of India's foremost privacy thought leader. Welcome, Vijayashankar sir.
Hi, good morning, everybody. Yeah,
Thank you for joining us. Chetandeep Batra, privacy leader at Ernst& Young, advising enterprises globally on privacy transformation. Welcome, Chetandeep.
Thank you so much, sir. Good morning, everybody. I hope we have a great discussion today. Yes, looking
Thank
forward.
you. Somesh Singh, Sikarwar, DPO at NSDL, operating privacy at national scale digital infrastructure. Welcome, Somesh.
Thank you. Thank you very much, sir. Thank you.
And from Data Safeguard, we have Ajit Sahu joining from US, covering universal consent management, AI and automation. Welcome, Ajit.
Thanks, Davam, for having me.
And we have Peeyush Tambe, all the way joining from Bengaluru, covering DSR, AI, and automation. Thank you, Peeyush.
Thank you, Davam. Thank you again.
Thank you all for joining us. So let's talk about DPDP and consent, from law to reality. Uh, Vijay Shankar ji, consent is the foundation of DPDP Act. Yet, consent failures are among the biggest compliance risks. From your perspective, where do organizations misunderstand consent under DPDP?
see, most of the organizations are familiar with the GDPR scenario. So, consent is also there in GDPR. So, I feel that they should be familiar with the way a consent should be obtained. Basically, a free and fair, say, explanation of why a particular data is required for the organization and seek permission from the data principal. So that basically consent has to be in the form of a contract. See, when we say a contract has to have an offer and an acceptance. The offer is the privacy notice, and the acceptance has to come from the data principal agreeing to share his personal data. And at that time, he needs to understand, as per the law, a proper explanation has to be given to him why the information is required. That is the purpose. Purpose-based collection is the most important aspect. That is where most of the misunderstandings today are there, because we see that most organizations have been providing what I call as a declaration, privacy declaration, saying that I, the company, respect privacy and therefore I do all these things. Okay. And in that privacy policy, most of the people call it as privacy policy. They expose it on the website and expect every data principal whose personal data is being collected by the organization to go through this privacy policy declaration and perhaps click a button at the end of it, I accept. Many of the people don't even have that accept button. They simply say that if you continue to browse the website, it is deemed to be your acceptance. Right. See, such things are not going to constitute legally a kind of consent as required. Secondly, when these privacy policies combine website visit along with, say, several of the products which the organization is offering, and each product actually is meant for different audience, and in this privacy policy they try to combine the permissions required for all the services into one single document. If you take an organization like a bank, see, bank may have, say, at least 20-30 products offered to every savings bank customer or a person who is just proposing to open an account. Now, if you want to combine all the 20-30 products, and each product will have several permissions, all that into one single privacy policy declaration, that is something which the law does not actually appreciate. Okay, but this is the legacy system which most organizations are using, and we need to make a change in this. What we call as privacy policy on the website needs to be restricted to the website visitors who may or may not be interested in any product except information which is provided by the website. So for that information, most of the time, no personal data is required. What is required is perhaps the technical data like the IP address, the browser information and other things, which mostly we call as necessary cookies. Everything else is optional. Okay. Now today, if you go to any major website, at best you have a cookie policy which says that I have got necessary cookies, I have got analytical cookies, but many of them don't give details of what are those necessary cookies, what are those analytic cookies, what kind of personal information these cookies collect. Different cookies collect different personal information. So there is a totally misapplied consent framework as of today, even amongst very respected organizations. So I think understanding that a consent requires a privacy notice has to be purpose-based, and depending upon the purpose, you have to define what exactly are the data elements required, how long you will retain, how you will process it, to which data processors you share. All these things have to be mentioned in the purpose-specific, say, privacy notice. Now, what people want to have as a policy, they are free to have a privacy policy for internal documentation, but for the external data principles, what is relevant is the privacy notice. I think this is the fundamental aspect. Second aspect is how to get authentication. Now, at least you should have a I accept button being clicked, so that you can capture the metadata and then perhaps create information to say that yes, this particular privacy notice was displayed and it was accepted. But having a deemed compliance that if you continue to browse, it is considered as acceptance is not acceptable. So rest of it, of course, what content has to be there, DPDP explains a couple of things. That is not difficult. Language also, I don't think personally is a great challenge today. Translation is not that difficult. So basically, organizing purpose-based multiple privacy notices and having authenticated acceptance, that is the challenge which most of the people have to fulfill right now.
Absolutely. No, well said, and thank you very much, Vijayashankar ji, for your insight. I appreciate your time. And under DPDP, consent is not a checkbox. No, it is a system of record. So let's talk about universal consent management at scale. So we have Ajit. Ajit, enterprises manage consent across website, apps, CRMs, ERPs, and no, and other partners. Right? Why universal consent management critical under DPDP?
See, I think the biggest misunderstanding around consent under DPDP is that organizations still see it as a one-time UI action, not a system capability, right? So many team believes showing a banner or capturing a checkbox is enough, but it is really not. But the DPDP is really about purpose, control, traceability across entire data lifecycle. So in practice, a script still fire before consent, cookie are misclassified, and downstream systems like analytics, CRM, ERP keep processing the data without knowing the user consent data. But the DPDP also pushes us toward just-in-time, purpose-specific consent, asking only when data is actually needed, not upfront or generic. So the DPDP also talk about like little bit about like the AI also, and we need AI for quick classification, auto scripting, blocking until consent signal, then flow into downstream system. Not before user consent. User need to give the consent and why the consent he is giving for, or who or he or why they are giving the consent. So the consent isn't a banner or a legal checkbox. It's the infrastructure, right? So not every enterprise they have the infrastructure, and once the organization get that, compliance turn into a cost advantages for them. So let's talk about UCM, right? It's a universal consent management. What exactly it is, right? So let me take a step back. It frame why universal consent management is so critical for DPDP, especially for a large enterprise, right? Large enterprise, they have like tons of data left and right flowing through the system, right? They have no control over the data. So you need a enterprise level architecture. That is something called UCM kind of thing we need to need it. So most organizations today manage consent in a very fragmented way. The website has a banner, the mobile does something slightly different, might or might not have like that one. The CRM system have their own preferences. ERP don't really think about consent at all. And partners often operate on contracts and assumptions. So on paper, each system look compliance, but when you step back, no one actually has complete end-to-end solution today. So the fragmented creations of real compliance is having a blind spot today. So one system may respect consent, other system may or may not be respect the consent, while another continue processing data without awareness. They don't know what exactly where the data is flowing through. And under DPDP, that is risky. That's really risky because compliance is not about like capturing the data. It is about enforcement control. So you need to know where your data is flowing. So now DPDP really changed the conversation here. It is not asking organization to collect more consent. It is asking them to manage the consent better. So then we need the UCM system. You can see all of your data in one place. So it is the core actually. The DPDP requires a single source of truth, and UCM will fulfill that one. So one authoritative system that can answer at any moment, we gave consent for what purpose and what processing is allowed right now. Without that, consent becomes scattered and metadata, not a governing signal. So another thing also, like there is a major shift to what DPDP introduces this idea that consent must travel with data. Consent doesn't stop at the website or the app. Once the personal data moves downstream system, let's see it move into the analytics, marketing, or credit hub or CRM, as you said, ERP, or anything, any partner site, or it will be connecting to anywhere, right? Any data that here you're going to go show your dashboard. So the consent context has to move with it. So if consent gets stripped away, the data, the system enforcement breaks immediately. So we need to put a break over there. And this is where most organizations struggle today. Now let's be realistic, right? This cannot be done manually at enterprise scale. Digital environments are dynamic. Scripts are injected on the fly. So cookie changes, vendor involved, a lot of things actually down the line it will be involved. So the manual rule-based approach simply don't keep up. This is where the AI becomes the foundation for this one. Not a nice to have, it is necessary. So AI is enables real-time cookie classification, automatic thing blocking until consent is given. Now, if you see the today, we are actually capturing the cookie, right? We are giving the consent. Before that, the script is already processing. So we don't have any control. So we need to have a control, how to control that process before you give the consent.
Yeah.
So for that one, you need a powerful system. So that powerful system AI will be fulfill that one. So instead of reacting after violation occurs, AI allows organization to enforce consent at the moment of interaction. That is known as just-in-time consent.
Great.
And finally, the unified automation is what truly reduces the legal and audit risk because we'll be having everything in one place. When consent, decision, and centralized, enforced consistently, logged automatically. So you are no longer rely on policy document or screenshot to prove compliance. You have evidence in hand. Okay, here you have a traceability and you have demonstrated to the compliance officer, whoever or the auditor they have it, right? You can show it to them. So the real shift under DPDP is this: consent is no longer a banner, it is no longer a legal checkbox. Consent is operational infrastructure. And organizations should have, and they need to understand that one very clearly. Don't just reduce the risk, they will build the trust at scale. So
Super.
this is how you will do your fulfill their risk as a scale, right? They want to use a enterprise level infrastructure like UCM.
Sure, sure. No, thank you, Ajit. And yeah, without unified consent, rightly you said, without unified consent or automated consent, compliance cannot be proven, only claimed. So let's talk about data principal rights, the stress test. Welcome back. Request Somesh. DPDP gives strong rights to data principles. From a DPO's lens, what makes DPAR execution so challenging? So, Somesh.
Okay. So yes, with the coming up of DPDPA, so we, as what as mentioned, that their consent plays a very big role. So here we are majorly looking for the rights-based approach where the data principle have been given certain rights such as rights to deletion, right to correction, and right to grievance redressal. So these rights-based approach is in and all it becomes, as from the legal lens, if we see them, this seems to be a very valid and legit case because it's the data principal who owns the data, so they must be given those rights. But making them work out in a technological perspective, it is not that easy, because if I can tell you about the organizations such as big organizations like national level organizations, there are thousands of consents which are coming at a single time. And imagine the scale of imagine the scale of rights which are catered to in a single time. Like, you are getting the request of deletion, you are getting the request for excess of data, you are getting the request for correction, all sort of things, and that too with such high huge user base. And not just small organization, but take into account any big organizations like NSDL, National Stock Exchange, Bombay Stock Exchange, or any sort of, this I'm talking about the BFSI sector like SBI Bank, IDBI Bank, or ICICI, HDFC, any sort of BFSI. Like, I'm sure this scale is quite huge to cater to the principles based, the data principle rights based request at a single time. So yes, the technical stack which is required should be very holistic and should include the modernization and the advancement in the technology, as what very well said, the use of AI.
Yeah.
Because AI will not only complement it, but AI will help us to uh, to actually contextualize. Because I was reading one research article where it was saying that how you can contextualize the personal data in the discovery part, so that you can get into the more relevant data structures, and you can work on that with respect to data principles, rights requests, as well as the consent management as a whole. So I would say yes, that's a very challenging task, and I think big IT companies and especially the companies which are specializing in the privacy field, they have this onus to
Yeah.
advance their part in this intricacies and this complexities of this coming up, which are coming up with these laws, to give out the product in the market which is very well accepted and make compliance with these privacy legislations easier to follow and kind of seamless. It shouldn't be putting the stress on the compliance head or to the board of directors that how they're gonna do it. Rather, it should work in a two-pronged manner. First,
Yeah.
making the work of compliance head or DPOs or board of directors easy, and at the same time making giving the rights to the data principles and the consent management overall in a very seamless manner. So it should be a win-win situation overall. And yes, definitely AI can be a big help in this, where in AI we can use, or not just AI. I was yesterday I was in a conference where we were discussing about how we can use blockchain in the consent management. And I think that's a very legit case, because consent should be immutable, which blockchain
Yeah.
provides. So these advancement in the technologies of coming up with these sort of things, I can definitely vouch that this will help in India to be a front runner in the privacy world. Even though said that, like having said that, CCPA came way before, then GDPR in 2018, and now we are DPDP in 2023. But with coming up of these systems in
Yeah.
place, which can by the usage of this advancement in the technology, we can be way more a front runner in the overall privacy management for the enterprises and other MSMEs as well.
Thank you. No, thank you, Somesh. Yeah, DPAR is where privacy maturity is truly tested. So let's talk about DPAR automation or DSAR automation from, let's say, process to trust. Piyush, many organizations still manage DPAR or DSAR manually. So how does AI-driven automation change DSAR execution? Piyush?
Yes, thanks, Somesh. It's a great question, and it's one I hear a lot, especially in the context of DPDP Act. The reality is that many organizations are still handling data subject requests manually, and it's like emails are coming into some inbox, and spreadsheets are made to track all the deadlines. There is a lot of back and forth between the different business teams involved, like IT, HR, legal, so on and so forth. And it works for a time until it stops working when we are talking about large scale. And under DPDPA, where timelines are accountability and demonstrability really matter, that manual approach becomes risky very quickly, because you run into a risk of getting out of compliance and heavy penalties. So AI-driven automation approach changes the game, where DSAS or DPAS, as the DPDPA calls it, becomes far more structured and predictable. So the first is the request intake. So instead of requests coming in from everywhere into different emails and so on and so forth, we can have a centralized portal or a single channel where the requests can come in. Then what's powerful about the AI-driven approach is that these requests can be immediately categorized into access, erasure, or forgotten, or rectification or correction, or grievance redressal, so on and so forth. So that classification happens automatically and without someone manually interpreting the request. And from day one, the request is logged, categorized, and routed correctly, and the compliance clock starts ticking in a controlled way. Second, like someone mentioned about the data discovery. So this is where most organizations struggle today. And under DPDPA, you need the confidence that you have identified all the relevant personal data tied to a particular data principle. And manually, that means emailing different system owners and hoping that nothing is missed and all the data is aggregated correctly and identified correctly. AI flips that around. It can scan across structured systems like CRMs and ERPs, as well as unstructured data like documents, emails, shared drives, and quickly surface where all the personal data is likely stored. Importantly, humans are still reviewing and approving the results, but instead of searching blindly, teams are validating AI assisted findings. That saves time and significantly reduces the risk of incomplete responses and as well as penalties associated with them. Third, approvals become workflow driven instead of ad hoc. So in manual processes, approvals are often scattered. Legal team signs off on one email, then security team signs off on another, and then finally privacy team has to stitch everything together. With AI-enabled workflows, the steps are predefined. Legal reviews what needs legal judgment. Security confirms identity and verification. Privacy team provides the final approval, and everything happens in one place. And every action is logged automatically for audit. And that consistency is crucial under DPDPA, where accountability isn't just implied; it is expected. Fourth, SLA tracking becomes proactive instead of reactive. DPDPA has clear expectations around timely responses, and as request volumes increase, keeping track manually just doesn't scale. AI systems track deadlines in real time, flag requests that are at risk, and reaching compliance windows, and even help prioritizing based on complexity or sensitivity. So instead of scrambling around closer to the deadlines, the privacy team can see the issues that are coming in advance and plan accordingly. And finally, regulator-ready evidence is built in. So DPDPA isn't just about responding; it's about being able to prove how you responded. And AI-driven platforms automatically maintain a full audit trail. So when the full audit trail, like when the request came in, how the identity was verified, where the data was found, who approved all the steps, and when the response was delivered. So if the data protection board asks some questions later, organizations can easily provide proof instead of having to dig through a lot of emails and spreadsheets. The evidence is all built in and in one place already. In conclusion, AI doesn't replace people in the DSAR or the DPAR process. What it does is it removes frictions. It takes away the manual coordination that is required, the guesswork that is inherently in place, and the anxiety about meeting deadlines. So, for organizations operating under DPDPA, AI-driven automation turns DSARs from a compliance headache into a controlled, repeatable process. And that's exactly what regulators expect to see, and that also helps all the enterprises.
Thank you, Piyush. I mean, great insight. So trust is built where rights are honored accurately and on time. Let's understand on the advisory view. Now, what regulators will expect? Now we have Chetandeep. Chetandeep, what will separate DPDP ready organizations, from exposure to one? I mean, you being into consulting, right? I mean, want to understand your view.
Yeah. So yeah, thank you so much for giving the baton. So yeah, see what clearly separate DPDP ready organization from the exposed one is the
Yeah.
evidence, which Piyush also talked about. It's not about the intent; it's about the awareness. It is about the privacy in practice, how the controls are being implemented. They want to see. They want to see the organizational implementation and how they're operational today in the real time
Hmm.
scenario. In many ways, DPDP represent a fundamental shift in regulatory thinking. It is not about the policy. It is not about the, I would say, a normal check boxes. It is about the execution driven experience they want to see within the organizations. If I had to critically evaluate the four differentiators, firstly, we have to define the controls mechanisms, how the data is being collected, how it is
Hmm.
stored, how it is being kept, and in what format it's being kept, and how specific we are as per the purpose compliance. They want to see how data is personal data access is restricted. They want to see how the access mechanism is managed, how role plays permissions are performed, and how audit logs are maintained to avoid those exposure data. It is about these simple demonstrations that control makes it effective and all together make it a organization's ready compliance need. Secondly, we call about strong linkage between policy, process, and technology. See, more organization draft privacy notice, internal policies, and something like that as a DPO requirement there. But challenge arises when these policies are not reflected in the operational system. A privacy notice may state that a principal request will be handled within the specific timelines, but how those are managed within through the email, spreadsheets, or manual coordination, or through tools. So accordingly, we have to demonstrate experience, exposure, how data is being handled, how it is being shown, how the system works in executing that workflow, from right from the intake to right from the to intake, verification, routing, and also the closure. When the policies are assigned, the things become more defensible and they are more compliant, and the probability of being data being fragile becomes a less prominent
Sure, sure.
here.
Yeah,
Thirdly, we have the automation backed evidence. When we are creating a workflow now within any tool, or online tools, or within any, I would say, a circumference, when we are integrating the website with the tool integration and DPDP requirements or DSR there, they must want to see how the consent is record is maintained, how the complete DSR record is, how the access log is maintained, and how they are approaching the breach timelines as well, while making a, I would say, strong challenge to create a defense for the regulatory compliance there. How the consent is withdrawn, how the purpose is driven. So it is all about the evidence collection and how exposure is done. Lastly, but not the least, we have a DPO requirement. So yeah. So, however, see, it is not about appointing a DPO and just putting him on the board and start the
yeah,
things act as a privacy here. He must know the advantage and the disadvantage of a company and how to cure themselves from the, I would say, how to cure themselves from the, I would say, exposure, visibility, how data flow is managed, and they must know how the functioning works and making all
yeah,
effective, right from the data collection, notice is being given, consent being managed, and how it is being withdrawn, and what are the circumstances when their data
yeah,
is
yeah,
transferred to a cross-border from out of the
yeah,
country. So this is the stuff when we definitely look out, because I have been interacting with
right.
many clients in my company, so we know how this works. And it is not about just I would say a mere checkbox. We must prove the compliance in real
Yeah.
time, and that evidence can do it, and we can protect it from getting exposed and overexposed.
Great.
Yes.
Thank you, Chetandeep. Somesh, I understand you need to go, or you
Yes,
want to
yes,
continue for a few
yes.
minutes?
I have a meeting, so I
Yeah, please
have to
feel
do a
free
meeting
to
with
leave the
the
studio. Thank
MDs.
you so much, and we will continue the conversation
Thank
in
you,
a couple
sir.
of minutes. Yeah.
Thank you so much,
Thank
sir.
you.
Thank you so much.
No, no worries.
Thank you
No,
so
no,
much.
thank you, Chetandeep. We will continue the
As
discussion.
Somesh,
Yeah, yeah, absolutely. So well said, Chetandeep. Regulators will ask, show me how this works, right? So yeah, so question to audience. What is your biggest DPTP challenges today? Consent, DSR, DPAR, automation, or readiness? If you have any question coming to your mind related to DPDP Act, please feel free to comment, and we will answer you back after this session is over. So let me again come back to all our esteemed speakers. So what is one line you want to talk about as your closing thoughts or remarks? Vijayashankar sir.
So most of the speakers have highlighted the need for AI to be used at different points of time.
Yeah.
I agree that the challenge is so complicated that perhaps AI is considered essential. But we must remember that AI itself poses certain unique risks, and that has to be recognized and managed along with the other kind of risks. If AI makes a mistake, the responsibility definitely is on the organization. So that needs to be taken note of. Second, Mr. Ajit was talking about this constructing the data inventory. Okay. Now, the question is when you create a data inventory and link it to multiple purposes, we actually have been discussing that identification of data and then putting into the inventory is better achieved through a process-based, say, compliance framework. That is, instead of running a software on the entire enterprise data lake, we have been suggesting that first create an inventory of processes, then within the each process, identify a process leader. Let that process leader take the responsibility of identifying whatever personal data is being processed by his process. That way, you are actually trying to micromanage the things, and then you can always consolidate that into a larger data inventory, because the data inventory needs to have a unique uh, data ID, unique consent ID. All this is required for later on managing the TSR or whatever the rights management is there. Nobody referred to the right of nomination. In fact, that would have been more relevant for NSDL kind of a thing, where the personal data directly represents a financial asset, and the right to nomination becomes very, very critical. It may not be so for many other organizations like NX or something like that, but for NSDL and even for banks, more than the banks in NSDL, because every data element there represents a financial value. So valuation of data and then ensuring that this nomination is accepted is going to be a challenge. I don't know whether your unified consent system is geared towards getting nomination consent, okay, with whatever complications are there. Just as we have complications in the consent of minors, consent for nomination, identifying a nominee, identifying the contingent event when nomination becomes effective, identification and executing it is a process which the data processors of today are not normally as comfortable with. They are not aware of, because in so far that was not necessary. So I think these are some of the things which the organizations need to work on from in future. Thank you.
Thank you, sir. Great insight. Chetandeep?
See, always the best. If when I talk about DPDP, now I always come to picture about consent management here. See, it is not about just proving that we have a checkbox there. It has to prove the validity, the purpose-driven necessity, and the withdrawable requirement here. So here we are fixing it that through the consent we are collecting through the banners, forums, or mobile applications, or through the call centers. We must know how it is documented within, and what is the source of truth carrying from the collection point of view till the end point of view, and what are the legal bases also being used along with the consent to define and demonstrate the compliance all in all. So here the only challenge I definitely got is the consent mechanism, and I am very much inclusive how the things gonna unfold in coming times and in the coming page here, when we are able to the also using the AI as well. We are understanding the theoretical concept, but also effectively implementing to the all the systems and the withdrawal mechanisms to understand the customer requirement, and also making it critical for the, I would say, businesses to react and also observe what is the uh, inconsistencies they are dealing with, what are the traceability they are dealing with, and on the other real-time visibility the customer want to see and want to engage through the data lifecycle management.
Great. Thank you, Chetandeep. Ajit?
So I just want to add actually what Chetandeep said, right? He is like truly said it's not about it banner or checkbox, right? You can go and check it and you don't know where your data is flowing. So the moment you give a checkbox, right, you are giving a consent to something, right? You need to know like where your data is flowing. And the moment you withdraw that consent, you need to make sure your data is not flowing and your data is not used somewhere that's not supposed to be used. So the one platform that will be having, right, that will help you actually to see, okay, whether your data is like used somewhere, or after you consent is like withdrawn, or after you consent is given, where exactly it is flowing, and for which purpose. So that is very, very important for like a consent point of view. And
Thank you,
then
Ajit. Yeah. Go ahead. Please close
No,
it.
no,
Yeah.
and the AU power, right? So everywhere you go and use the AU power, and you can see like it will give a lot of capability where you can go and use your AI power, and you can classify external cookie, or you can block your consent. A lot of things we can do, and everybody excited to use like the AI power feature in coming days.
Thank you, Ajit. Piyush?
Yeah. So I'm in agreement with what Chetandeep and Ajit also mentioned that, evidence-backed automation is what the regulators will look for. And in the context of DPARs as defined by DPDPA, the AI-driven automation for DPARs will turn it from a manual compliance risk to a predictable, auditable, and regulatory-ready process. So we would have all the audit trails, all the evidences, and all the actions performed in one place, so that the auditors and regulators will find it easy to track.
Super. Thank you, Piyush. So DPDP compliance is not about avoiding penalties. It is about earning trust at scale. Organizations that embrace universal consent management, data principal rights by design, and unified privacy automation. All our speakers talk about that. Will not just comply; they will lead India's digital trust economy. So thank you to all our esteemed speakers and to everyone who join us live today. So we'll come back with another topic and sometime soon. And thank you all our speakers. Thank you.